Okay, an update in the Julian Assange case that I am bringing, requesting judicial review for the arbitrary detention of Julian Assange. It's now moved on to the appeal court. The main judicial permission request for judicial review has moved on to the appeal court. I'm actually asking permission to ask for permission at the appeal court, and at this permission stage at the appeal court, Mr. Martin Spencer, John Bethel, has provided this written statement on behalf of the Secretary of State for why I should be refused permission to appeal for judicial review of the Julian Assange case. I'll read it for us. It's quite intimidating if you're inclined to be intimidated. So, 1. This appeal concerns an application for permission to apply to judicial review of what the appellant, Mr. Hesford, describes as the arbitrary detention of Julian Assange. Mr. Assange was arrested, tried and convicted on 11th of April 2019 for an offence of failing to surrender to bail. Under Section 7 of the Bail Act 1976, he was remanded in custody until the 1st of May 2019, when he was sentenced to 50 weeks imprisonment by HHJ Taylor at Southwark Crown Court. He is presently serving that custodial sentence. On 13th of May 2019, Martin Spencer J. considered Mr. Hesford's application for permission to apply for judicial review on the papers and refused permission, certifying the claim as totally without merit. Quite forceful stuff, as I said. His title is Justice Spencer, Justice Martin Spencer. It seems quite ridiculous that you can argue against the case for sure, but to say it's totally without merit when I'm standing on the submission of Julian Assange to the UN body on arbitrary detention, and also on the UN verdict, and obviously I can now, I can try to submit further the UN Special Rapporteur for torture. I will eventually try to submit. I have my own arguments in my bundle, but I stress that I'm relying heavily on these judgments and opinions, and whatever I've encountered makes no attempt to engage with those arguments laid down. Following that refusal of permission, the only correspondence that the Secretary of State received from Mr. Hesford was in relation to 1. the costs of the judicial review claim, and a separate application for permission to appeal that he has filed in relation to an interim decision of Justice Dove. That interim is to request outright that Julian Assange be released on terms of a writ of habeas corpus. That interim, my case is essentially split in two. It now comprises of a case which some time ago already arrived at the appeal court, requesting a hearing essentially on habeas corpus, and this main request now for judicial review. So it continues. That remained the position until the 6th of August, when the Secretary of State's solicitors received a letter from Mr. Hesford enclosing an appellant's notice and a letter from the Civil Appeals Office dated 2nd of August stating that the notice would be treated as filed on the 20th of May. The circumstances in which the appellant's notice was filed are unclear. If it was filed on the 20th, it's perfectly clear. If it was filed on the 20th of May, then Mr. Hesford evidently failed to serve it on the Secretary of State promptly and within 7 days as required by CPR R52 blah blah blah. So it is true, and I have failed in that regard, but trust me, these opposing parties make their own failures, and I don't believe that this failure will bring about such serious censure as to amount to the application to be dismissed. You see, in my correspondence with the appeal court, I've done everything they've asked within the timescales told and taken reasonable measures, but it does seem to turn out that, well, let's just explain it this way. When I file for judicial review, I either send or go to the High Court, submit my form, they give me the sealed form, and I serve the sealed form, right? Now it appears that at the appeal court stage, they want you to serve the form prior to it even being sealed as you know, allowable. But I don't think that's a big thing. In any event, the Secretary of State opposes the present application for permission to appeal for the reasons identified by Martin Spencer in his order. The underlying claim was rightly certified as totally without merit, that is to say, bound to fail. Quotes some case, you know, that says, it's kind of funny that you don't get your time in court to argue your case and it be judged. They judge it prior to whether it has any chance of success and dismiss it, potentially. As I would say, they've been entirely too superficial in finding my case bound to fail when they've not even attempted to address the issues outlined in my bundle submissions. So it has no real prospect of success. There is no other compelling reason for it to be heard. So now he starts to add meat to why this is the case. First, Mr. Hesford lacks standing to bring a claim for judicial review in respect of any detention of Mr. Assange. Mr. Assange is quite capable of challenging his own detention should he wish to. He has been a prolific litigant represented by an extensive legal team over many years. There is no basis or need for Mr. Hesford to advance a judicial review claim on behalf of Mr. Assange. Indeed, so far as the Secretary of State is aware, he is not authorised by Mr. Assange to do so. Moreover, Mr. Hesford has plainly misunderstood the notion of public interest litigation. You see, when you read the help documents on judicial review, there's a great emphasis at one of the junctures about the matter of what you call standing, locus standi, also referred to as sufficient interest. Now, when it explains the importance of having this standing business, an issue I've met previously, it subscript notes and tells you to go reference a case and explains to you that this is quite as simple as it might sound, in the case of public interest cases that are of public interest. Now, Mr. Jonathan Bethel can claim all he likes about my misunderstandings about public interest. I'd say my understanding of public interest is entirely fine. Right? I've made argument about this in my representations. It's prior to this barrister making this submission, the government legal department actually seemed to think public interest meant like public gossip interest, like a fervent, there is a media interest. This is of interest in the sense of people are curious and want to know. This is obviously a complete absurdity and is obviously completely not my position on the matter of public interest. The key case, which it slips my mind for the moment, which is cited and provided and stated and claimed as the key case about public interest litigation, is about what is in the public interest, and the fact that in principle, in law, in this case, basically any Joe Bloggs is entitled to get wrongdoing stopped, yeah, when it's a public interest case. So regardless of how firm and authoritative that first point at paragraph 4 might read, I find it quite vacuous. Secondly, the judicial review claim and the present application refers to Mr. Assange's situation in the period prior to his arrest, when he resided at the Ecuadorian Embassy in London. That situation no longer obtains, and the challenge to it by the claimant is thus academic. Well, it's not academic. Academic would be to say that it's only an issue on paper. The fact is my government is in the business of arbitrarily detaining people. It has been cited and adjudged guilty already. I intend to hold the government to account. It's not academic, it's actually happened. And authorities way above me have cited it as happening. The fact that my submission relates to the period prior to his arrest is quite what's the word, coincidental. The fact that I submitted this request for judicial review unbeknowingly on the very day that he was to be dragged out of the embassy. And so there is a caveat, there's a kind of a piece of luck here, that had I not done it on that particular day, it's very possible that I'm very easily thwarted this attempt for judicial review by virtue of a section of law in the High Court Act or something, which prohibits criminal proceedings, anything to do with criminal proceedings, being dealt with in civil court. But as I've detailed in my application, the justices here will have to be very cautious not to prejudge. The very fact of a claim of arbitrary detention is to claim that it's out of the remit of the criminal justice system, which might be, let's say, less arbitrary. Thirdly, Mr. Assange is now serving a lawful sentence of imprisonment. it was open to him to challenge that sentence or his conviction by way of criminal appeal. Judicial review proceedings are not a proper means to challenge those matters. Okay, so I am not acting on behalf of Julian Assange. Of course I want him free, and of course I think that the government is acted wholly unreasonably. Right? I'm acting as a person accusing my government of being in the business of arbitrary detention. The contingencies, the ifs and buts, and what Julian Assange could do or could do if he liked to do are of no concern of mine. Right? His legal priorities and his advice he gets from counsel, I'm not privy to, and if they feel their particular fights are not best at this time under very large financial demands of that representation, best represented by the request for judicial review, and I can fully understand that, given the pressing nature of the criminal and extradition proceedings which he faces, that they do not find it at this time, and perhaps they do not find it expedient or best to go for judicial review. But this is all irrelevant to a citizen who wants to hold his government to account. For all I know, he may never decide, for whatever reasons, apathy, failing belief in the justice system, he may be extradited, right? Justice cannot be stalled on account of the contingencies of what Julian Assange may or may not decide to do. Neither the appellant's notice nor the skeleton argument filed with it improves on the case rejected by Martin Spencer. Well, as I say, they don't really deal with the bundle or any skeleton argument that I've submitted. The appellant's notice indicates at section 11 that it will rely upon bundle evidence already supplied. This is presumed to be the judicial review claim bundle, which consists for the main part a very large number of news reports. This is entirely false. Yeah. At this permission stage, the defendant, the government department, is not in possession of my bundle submission to the appeal court. Right? That's just a fact. I've only had to supply an index to them. And as for the news reports making up a large part, this is just nonsense. There's a number of references to news reports, just the titles, many of which are referenced in the Julian Assange submission itself. So therefore, I provide, and I'm potentially facilitating the actual source documents provision. Wherein people call for him is assassination and articles with targets, sniper target placed over his image and such. Many of these, that character. Furthermore, the grounds, and it may or may not come to bear on my case. I'm sure it will bear on the case to some degree, but the degree to which it bears on, I can't be sure. So I have to provide for eventualities. But the fact of the matter is, extradition can be stopped on political grounds, that if it's seen to be politically motivated. That opens the realm of political narratives, and thus news articles will become a source of the ongoing political narrative. The skeleton argument also invokes Mr. Assange's presence in the Ecuadorian embassy and a list of a series of questions at issue, without any indication of what submissions Mr. Hesford would seek to make on them. It is further noted that some of those questions relate to an application for habeas corpus, which was also refused by Martin Spencer J, and which seems to have been abandoned in this appeal. Well, it's not abandoned per se, it's just recognising that I've at an earlier time, which came to me at an earlier time and prior to refusal of habeas corpus, is I very quickly refused obtained a judgment refusing habeas corpus. Now, that judgment at that very early stage was immediately sent to the appeal court. So this is how we have a separation of cases. It's not abandoned, it's just ongoing in a different case with a different case number. Other questions are directed at the possible extradition of Mr. Assange rather than his current detention. Of course, in the political narrative, the risk, and now direct risk, of possible extradition will form part of that narrative that will be argued, that will comprise weight in the aggregate considerations of my arguments. So finally, John Bethel states, in these circumstances, the Secretary of State invites the court to refuse permission to appeal and to certify this application from Mr. Hesford as totally without merit. So I've already had costs of about £800 awarded against me at the initial judicial review refusal, but it's very difficult to get. I won't incur any barrister costs or court costs representing myself. It's only the other parties, and they'll find it very difficult to get monies out of somebody who hasn't got out. So there's that.